Good morning. We are here today to announce the expansion of our prosecutor-led expungement program to include youth cases. To our knowledge, we are the first jurisdiction in Minnesota to undertake this important initiative. With this new initiative, we are allowing people with certain youth offenses to apply to our office for expungement. Some time ago, the Attorney General's office established an online portal called Help Seal My Record. That allows people to apply to our office for expungement. If their case is eligible, our office does all the work. We file the paperwork with the court and follow up with the applicant. There are no filing fees in this process or court appearances required. Now people with certain youth offenses are able to apply to our office through this same portal. Under this initiative, we review cases committed by youth that involved misdemeanors and some low-level felonies, like drug or property cases. Cases, in other words, where young people have made mistakes, which kids often do as their brains continue to develop. This initiative is critically important. We know that all children are capable of changing and evolving. A child should not be defined by a mistake, which is what we see in many of the cases eligible for expungement. For instance, we know that a single act of drug possession is not indicative of a child's character or that child's potential. Yet criminal records, even for minor cases, can follow youth forever and can impact their ability to further their education, seek employment, maintain stable housing, and so much more. For today, I want to talk about just one example of the impact of these records. Department of Human Services, or DHS, background studies. For instance, did you know a child charged with a misdemeanor theft, things like stealing food from a grocery store, faces a 7-year disqualification from being able to pass a DHS background check or background study, which will keep them from being able to work as a PCA, personal care attendant, a food service worker in a nursing home, and so many other jobs. A child charged with felony drug possession, which could be as little as a couple of pills, faces a 15-year disqualification from passing that DHS background study. They don't even have to have been adjudicated delinquent, which is what we call convicted in juvenile court. And these disqualifications apply the same to records for children as they do adults. These are two of many examples of the ways in which records can negatively impact a person's ability to move forward from a mistake they made as a child. And we know that when people are able to move forward, obtain employment, housing, and education, it leads to better outcomes for those individuals and improves community safety. It is therefore imperative that we utilize expungements to ensure that when youth move into adulthood, they have the opportunity to progress beyond their childhood mistakes. Providing that opportunity for people who obtained records as children is especially important, which is why we have developed a prosecutor-led expungement process for youth. Expungements allow for records to be sealed, which essentially removes it from a person's criminal record. Expungements allow us to remove significant barriers erected by juvenile court records, barriers that hinder people's ability to secure employment, safe housing, and educational opportunities. Youth expungements allow us to ensure that we have accountability, while also allowing for growth and second chances. To date, the Hennepin County Attorney's Office has received 800 requests for youth expungements. We have reviewed over 230 expungement requests and filed an average of 20 expungement motions in the past 2 months, and submitted numerous letters of agreement in support of pro se filers, meaning people who have filed on their own who don't have lawyers. We are reviewing cases where people filed their cases pro se on their own, and we are reviewing cases submitted to us by the Public Defender's Office. We receive about 10 new requests per month. We are also working on a post-charge diversion program where we can expedite the expungement process after a person has finished their diversion program. We are proud of our work, and I'd like to highlight a few cases that stand out. Nearly 11 years ago, this office charged a 16-year-old with 2 separate counts of felony fifth-degree possession. This was his only delinquency offense, and now, as a 27-year-old, he has no adult offenses. He filed a petition to have these matters expunged. The office filed an agreement to expunge on his behalf. The court granted the motion within a matter of days, and his case is now expunged. Between the ages of 14 and 15, one youth struggled with delinquent behavior and picked up multiple property-related offenses. As an adult, he found that his juvenile priors severely harmed his employment prospects. He applied for expungement of 5 delinquency cases through the Hennepin County Attorney's Office online portal. Our office recognized the ongoing harm to the young man's employment prospects and will request that his convictions be expunged later this month. Another youth petitioned the court directly for expungement because her record was preventing her from obtaining housing and employment. In responding to the petition, the office noticed that while the case she listed was not eligible for prosecutor-led expungement, another matter on her record was. The office filed a letter of agreement with the court supporting her petition for cases she had filed on and filed for expungement in the case she hadn't listed in her petition. In the end, the court issued an expungement order agreeing to seal records in both of her matters. These are just a few examples of the many people who will be able to move forward with their lives as a result of this new initiative. I'm very grateful to the team that has made this work possible. Thank you to Morgan Coons, who's here with us today, and Paris Yarborough, who could not be here today. They have led the development of this initiative in our Youth Prosecution Division. Thank you to Nadia El-Negdi and Peggy Larkin, who work on our adult prosecutor-led expungement initiative and who provided templates and training materials. Thank you to the Bureau of Criminal Apprehension and the Department of Human Services, which ensures that all records are properly sealed. Thank you to the Hennepin County Juvenile Court Administration, who file and serve the necessary expungement paperwork. And thank you to the Hennepin County Juvenile Court Bench, who have worked with us to make this possible. We are better as a society and safer as a community when we recognize that people grow and change. And our Youth Expungement Project is an important step towards achieving both goals. Thank you. Any questions?
How quickly can people apply for this after they've committed an offense?
I'm going to ask either Morgan or Nadia. Morgan.
Yeah, sure. The waiting period depends on the severity of the offense. They can apply to the Help Seal My Records portal immediately. The typical waiting period is 1 or 2 years of law-abiding behavior to be eligible for the program.
Is this permanent? Once it's sealed, no matter if they were to reoffend in some way that was related to the previous juvenile case?
Yes.
Okay.
Why do this now? I know obviously you did it for adults, but why now? Why is it not the right time for youth?
I will just say we had to get our, let me back up. As you know, we've done 3 community expungement events held in different communities in North Minneapolis, South Minneapolis. The latest one was in the suburbs. And so we wanted to make sure we had the capacity to do it. We wanted to do this. And it was really at the initiative of our expungement team and Paris and Morgan. Other questions?
It seems like there are these, levels of cases that are not just directly eligible for this expungement, but it does appear that they can be heard.
Yes.
I want to understand that each case is taken on its own basis, and then your department sort of determines whether or not it has this.
Yeah, Morgan, do you want to?
Yeah, absolutely. Yeah, so you're absolutely right. We apply the objective criteria to determine if we, the prosecutors, are going to affirmatively file the paperwork. And even if we're not going to file the paperwork because it doesn't qualify, if the person has 10, 15 years of law-abiding behavior and has demonstrated rehabilitation, we will write a letter of support for full expungement, but that will require the scheduling of a hearing and more court activity.
Can you give like examples of like what like a fourth or fifth degree drug offense would be, or property for people who wouldn't know off the top of their head?
Yeah, sure. So a fourth or fifth degree drug possession case could be a young person at a school caught with a vape cartridge. Up until about 2 years ago, that was a felony offense in the state of Minnesota if it had marijuana in it. And that sort of, an adjudication on that can have really significant effects, as Mary described, moving forward. And then Mary also mentioned pills, you know, like a single Xanax pill or other prescription pills can lead to that type of charge.
This is a question I have no idea if there's an answer for. Is there work being done to determine if in general, as opposed to expungement, if in general these sorts of cases should not be part of background checks? Do you know what I mean? It's kind of an interesting space that I think about. I assume that'd be a legislative act or something along those lines, but has that ever been considered?
Yeah, I'll have Sarah Davis, our deputy, speak to that.
Good morning. Great question. So yes, there has been legislation in past sessions before the state legislature to look at, specifically, Mary talked today about the DHS background studies. There's a couple of options there. So as Mary mentioned, this law applies the same to a 10, 11, 12, 13-year-old as it does to a 50-year-old who engages in whatever the behavior is. And so there's been legislation that has looked at saying youth cases of certain types should not lead to background studies disqualification, or that the time period should be different, right? Because for a misdemeanor, it's 7 years, gross misdemeanor, it's 10 years, felony, it's 15 years. And Morgan talked about, you know, that could be one Xanax pill. A felony theft is over $1,000. I mean, in today's day and age, that's a laptop, it's a cell phone, right? And so in 15 years, and that it doesn't require a conviction or an adjudication, right? It's actually based on what they call a preponderance of the evidence standard, which says that which means that it could stem just simply from an arrest or citation. And so it's really problematic and really excludes a lot of folks. And so to your point, there is an opportunity for the legislature to act here.
We, in the middle there is what we choose to do when cases are submitted to us by law enforcement. We do have the option to do pre-charge diversion, which can be helpful, so it isn't actually an adjudication on somebody's record. And I know Morgan and his team look at each case very carefully to see what an appropriate response would be, and is it necessary to put up a barrier like this so that it needs to be expunged down the road.
Is there any element of this that you see as being, like we talked about that? I know that the county, not just your office, but across the board, has been looking at juvenile crime and trying to find ways to interrupt or stop patterns. Is that part of that?
You know, these are primarily, when we're looking at the, and for prosecutor-led expungement, we're talking about minor. So to take a step back, we prosecutor handle all youth crime in Hennepin County. That's misdemeanors, gross misdemeanors, felonies. As opposed to adult crime, we handle felonies throughout. So we approach youth from a number of different perspectives. As you know, we have the Youth Auto Theft Initiative, which is a preventative program. We are funding part of Youth GVI, Group Violence Intervention, to try to intervene with young people who are involved with guns, who may be the next victims or the person who harms somebody else. So we try to look at each child who comes in individually and see what their needs are. And try to come up with a disposition or a plan that fits that particular child's need. And that, I think, is really helpful in terms of addressing the child and the family's need, so that hopefully we can interrupt them from coming into the system. We also have Be at School. That is our truancy diversion program. We've expanded that greatly since I came into office, and that is also about getting kids in school, getting kids and families connected with resources so that they can actually be in school. So we approach this in a number of different ways, individualized to the child and the family.
Is there any time when a person can make this request, even if they are a grown adult at this point, but feel like they want a juvenile case taken up? Is it,
No, in fact, that reminds me of one of the people that showed up for our community, one of our community expungement events. I believe she was in her 70s, and she just wanted, and it wasn't a youth record, but she wanted something that happened in her past expunged because she just, before she passed away, wanted a clean record. So no, there isn't a limit there.
If someone is under 18, do they need their parent to do this for them? Like if they committed an offense at 13, they've been law-abiding for 2 or 3 years, and they're like 16.
No.
No.
And then has this been done in, I know you said this to your understanding for the first jurisdiction in Minnesota, has this been done in other cities across the country of similar size? If so, do you know how that is worked out?
Not that we're aware of. I believe we are the first office that we are aware of in the country doing prosecutor-led expungements on youth adjudications.
And then for some people who might say, you know, there's always going to be criticism for people who are like, well, who's overseeing kind of like your office and team? What would be kind of your response to that?
I have the greatest respect and trust in our team, our entire team that does expungements. Look at these cases very carefully. And ultimately, they have to be signed off on by a judge. So I suppose that is one area of accountability, but I have great confidence in our team who does expungements that they are looking at these cases very carefully.
And then, go ahead. I was just curious, I know you mentioned like if the team had like a Xanax pill, what if it was something like a fentanyl pill? Is that still included in this, or is that separate?
No, if it's a 4th or 5th degree drug offense, it would still qualify. The big thing is the waiting period, where people have to demonstrate their rehabilitation, and we see that based on the period of time since the offense happened.
Thanks for your time.
Any other questions?
I just have one more about, can you talk a little bit about the clean slate law now that it's a law, just kind of the impact that it has?
Yeah, so prosecutor-led expungement, records are expunged from the Bureau of Criminal Apprehension, Minnesota Court Information System, the Police Department, City Attorney, Sheriff's Department, State Attorney General, Department of Corrections, and the Department of Human Services. It appears that expungements through the Clean Slate Act only apply to the BCA and Minnesota Court Information System records. So I would say our prosecutor-led expungement is a bit broader than the Clean Slate Act. Thank you.